Hello, welcome to this week's video blog. This week I'm going to talk about the enforceability of waivers, which are incredibly common and powerful clauses in contracts we all come across almost every day. From getting on a chairlift or a Ferris wheel to renting a car, a bicycle, or a piece of garden equipment, or even leaving a jacket at a coat check, waivers are everywhere. Giving up or waiving the right to claim for the consequences of somebody else's carelessness is something we all frequently do. A waiver is a promise not to sue for an injury, death, or property damage arising out of an activity, including loss caused by the clear negligence of another person. BC is the most waiver-friendly province in Canada, and Canada likely the most favorable country in the world for enforcing waivers. Insurance companies like waivers because they reduce the number of claims they have to pay out because waivers reduce the likelihood their insured will be successfully sued. Businesses like waivers because they reduce the cost of the insurance, and when a business cannot get liability insurance, a well-drafted and presented waiver offers the opportunity to avoid legal responsibility for the negligence of the business and even its employees. For many people, the idea that they might be badly injured by the obvious negligence of another person and have no legal recourse to pay for wage loss or medical expenses can be frightening, and it should be. While many waivers are enforceable, they must meet several legal tests. In order for a waiver to be effective in removing somebody's right to sue for another's negligence, the waiver must meet the following three-part test. First, the waiver must actually apply to the facts of how the accident occurred. Second, the waiver must not be what's called unconscionable. And third, the waiver must not be against public policy. So, regarding the first part of the test, does the waiver apply to the facts? This means the court must consider whether the terms of the waiver include a description of the risks that caused the person's injuries. This means a waiver can only cover potential risks which were in the mind of the person at the time they signed the release. For example, if you're skiing, it's likely in your mind that you might ski off a poorly marked trail or injure yourself, or be injured in an avalanche, which could have been prevented. You would not, however, contemplate being shot by an employee who was carelessly handling a firearm or being food poisoned by poor practices in the ski lodge. That's not in your mind when you agree to a waiver. In other words, the cause of the injury that the waiver seeks to avoid legal responsibility for must be reasonably described in the waiver and be generally foreseeable by the parties. Clear language is required if a business operator wishes to release themselves from liability for the negligence of their employees or agents. The courts must also consider whether the participant actually understood what they signed. Generally, however, by signing a waiver, it's presumed that the participant has read and understood it. They have a duty to do so. The activity operator is under no special obligation to ensure that the participants understood what they've signed. However, where the operator knew or should have known that a participant was unaware of the legal or practical effects of signing the waiver, they have to take reasonable steps to advise the participant. This can arise where the participant was told to sign the waiver in a hurried or casual manner and not given adequate time to read or understand the waiver. The second main requirement of a valid waiver is that it must not be unconscionable. In other words, even if the waiver applies to the facts of the accident, the court may find the waiver unenforceable because it's unconscionable. To prove that a waiver is unconscionable, the person who signed the waiver and the person relying on the waiver must have been in significantly unequal bargaining positions. The business operator must also have abused this power to get the participant to agree to the unfair waiver. That said, participants almost always have the choice between agreeing to the waiver and participating, or not participating at all. Courts have upheld waivers in cases even where the participant has traveled long distances at great expense to participate in an activity only to find that if they didn't accept the waiver, they'd be turned away. The courts do not generally view inconvenience suffered by a person because they cannot partake in an activity unless they sign a waiver as an inequality in the bargaining power that makes signing the waiver unconscionable. The third main requirement of a valid waiver is that the waiver must not be against public policy. That is, the waiver is contrary to the interests of the general public as a whole. The power to overturn a waiver because of public policy is rarely exercised by the courts in BC. Waivers in adventure tourism activities, for example, generally do not give rise to public policy concerns because, by definition, these activities have inherent risks and people generally expect some risk. Many activities, however, with reasonable care of the business should be low risk, and a court might find it against public waiver where to do so would discourage routine safety practices. A properly drafted and presented waiver can provide business owners with strong legal protection from claims. However, it should never be assumed that a liability waiver will provide complete protection from lawsuits. In cases where there has been significant injury or property damage or death, a judge should always be asked to decide whether the waiver is enforceable. If you have questions about this issue or another legal issue, please feel free to contact us for a free legal consultation. Thank you very much.